This has been a very tough week for the women of Ireland. Last night we had a heart-wrenching and emotional debate on the government's proposals to seal the records of survivors of mother and baby homes, women who were vilified, abused and treated as outcasts by this state. And in the same week, issues surrounding cervical check have unfortunately arisen again. 12 months ago, Taoiseach, you delivered a formal state apology for the litany of failures in respect of cervical check, and you said sorry for the humiliation, disrespect and deceit meted out to the hundreds of women affected by that scandal. This came in the aftermath of the state joining US laboratories that were at fault in dragging a terminally ill woman through the courts and fighting them tooth and nail every single step of the way. It was accurately described as a deathbed litigation. You gave a promise, Taoiseach, that the women concerned that this would never happen again and that an alternative to the courts would be provided for women to seek justice. The truth is that this adversarial and aggressive approach has been maintained. Vicky Phelan has now come forward to express her shock and anger that women and their families have been let down by the state yet again this week. Minister Stephen Donnelly has now written to the women and their families to say that the tribunal will be established next week. And they got that news the same time as the public announcement. And Taoiseach, it's like the mistakes that were made were just made, brushed under the carpet, forgotten about, and as if the women concerned, their voices don't matter. And that's what we heard last night, women saying they felt their voices didn't matter. Against their wishes and pleas for a non-adversarial route, the Minister has flatly ignored these calls. Instead, he is insisting that the labs must be involved in the proceedings if taken before the tribunal. This is entirely wrong. The government should not be joining with these labs in fighting these women and their families. A decent government would stand up for these women. A decent government would protect them and ensure that they worked with them to get the justice that they deserve. Taoiseach, we need to fix the system, and that is the very least that we owe these women. Taoiseach, I am a user of the cervical check service. I want that service to work, and in order for it to work, there has to be transparency, there has to be trust. And the women who are the victims of this scandal have got to be listened to so that all women can know they can have confidence in the service because they are having an input into that service. These are the women who have been let down time and time again, Taoiseach, and now the Minister for Health intends to proceed on a basis that is not acceptable to those women. Vicky Phelan has said that she is pleading with the Minister to redouble efforts to sit down again with the members of the 221 Plus group to identify an alternative solution of redress, which is what our members have asked for and what they deserve. This is what they deserve, Taoiseach. Will you accept that there is a failure here to live up to the promise that you gave when you were Taoiseach, that women would not be dragged through the courts and through an adversarial process? Will you accept that this has caused huge distress and upset for women and their families, all of which could have been avoided? And finally, will you intervene now ahead of this tribunal being established next week and ensure that the cruel treatment of women is stopped immediately and that the tribunal is constituted in a way that will deliver justice for them?
Thank you very much, Deputy O'Reilly. Taoiseach.
Thanks, Deputy O'Reilly, for raising this very important issue here today. The Cervical Check Tribunal is being established in good faith by Government, honouring a commitment made by Government following on from the Menon report of 2018. It is being established as an alternative to court for those who want it, where cases can't be settled by mediation or negotiation, which of course is the preferred solution and has happened in many cases, but isn't always possible, particularly when there's a dispute about the facts and whether there was negligence or not. The idea is that the tribunal is intended to be quicker, that there will be fewer legal costs, that it can be done in private, and that it can be less adversarial as the tribunal will have access to independent experts. Minister Donnelly has met the 221 group. I heard him this morning saying that he is willing and will be happy to meet again with the 221 group to hear their concerns, sit down with them, listen to their ideas and suggestions, and he has made that commitment, and I think that's welcome, and I know he's going to follow through on that. Just in relation to the whole issue of a system being adversarial or not, I think it is worth paying attention to the words of Justice Mary Irvine, and what she says is that adversarial in this context describes a process by where the evidence of each witness may be tested on cross-examination. It doesn't necessarily mean that it has to be confrontational, and unfortunately in some of these cases it may not be clear-cut. The person taking the case may feel that their smear was misread negligently. However, the scientist that read it or the doctor that signed off on it may feel otherwise, and then there's a dispute about the facts, and what happens is the evidence is set out and each side gets to question the evidence, and that is what happens, and it's hard to come up with, I think. I haven't seen anyone yet who's come up with a solution to get around that, because I don't think it'd be fair to deny a scientist or deny a doctor the right to be heard, the right to say, I wasn't negligent, I actually read the smear correctly, and I haven't seen anyone yet who's managed to come up with a solution to that conundrum, other than to refuse to allow people to make a defence, and I don't understand, I don't see how that would work. Just in relation to the whole issue around the laboratories being involved, I understand what is possible following on the recent Carrick case in the High Court, is that the laboratories can be involved as third parties rather than as defendants, and that would follow on from the Morrissey case, which established that the HSE has primary liability and cannot delegate its liability. So it will be possible in cases for the HSE stroke the state to be the defendant, but the laboratories will be only there as a third party, and again that may be necessary because the third parties have indemnified the state and will have to pick up the tab for any compensation. But if they're totally excluded from saying that there wasn't negligence, then obviously that would create an issue and would require the state having to sue the laboratories, thus resulting in a second trial and a second court hearing, and I don't think that would be in anyone's interests at all.
Thank you. Tánaiste, Deputy O'Reilly.
Tánaiste, you've just read out a description of the process that's been rejected by the women and their families, and I genuinely do not believe that you are doing them any service by seeking to either defend that or indeed dismiss their concerns in this way, and I don't think you're being fair, Tánaiste. You say that there's no perfect solution or that there's no solution offered. Well, can I put this to you? Would you not intervene and request that the Tuesday deadline be lifted to give time for proper, meaningful engagement with these women? And remember where this came from, Tánaiste. This came from the fact that women were information about their own health care and their own diagnosis was withheld from them. So they've already been left out of this process. They've already been sidelined. They've already had the state try to shut them up. And I really do genuinely think, Tánaiste, that you should intervene and request that, if need be, the Tuesday deadline is put back to allow for sufficient time and engagement with the women and their families in the 221 Plus group.
Tánaiste, please.
Thanks, Deputy. The Minister for Health, Minister Donnelly, said this morning that he is happy to meet again, engage with, listen to and speak to and sit down with the 221 group, and it is of course his judgment then as to whether or not the government on Tuesday would make a decision to defer the establishment of the tribunal, and obviously I'll be guided by him in that regard. But bear in mind, it is being set up as an alternative to court for those who want it. Nobody's ever suggested or suggesting that somebody wouldn't be able to go to court if they felt that was in their best interests. It is the wish of everyone in government, and I think everyone in this House, that as many cases as possible should be settled by mediation and by negotiation. No need for a court trial, no need for a tribunal, and that is happening in a number of cases. But there is a real issue, and it is different to other issues in the past. There is a real issue where the facts are disputed, where the person taking the case on the one hand says that their smear was misread and has experts to back that up, and the doctors and the scientists on the other hand say, I didn't misread that smear, and I have a right to defend myself and a right to say that I didn't get it wrong. And I'm not sure what you're proposing. Is it that you would like to take away that right from them? I don't think you're proposing that. So that is where the difficulty arises.